going to kind of run through these screens on what we've got coming up. We're super excited to share the information and get y'all engaged. Not engaged, but and huge shout out to our Facebook friends watching us live. Thank you for being here. We appreciate you so much. All right, so next month, and I know you mentioned Chick-fil-A. Everyone knows who Mr. Jeff Johnston is. He will be here presenting on client connection, finding and keeping customers, which is very important, as we all know. That will be on Wednesday, July the 10th, from 11:30 to 1. Make sure you go and get registered for that. I also need to give a huge shout out and thank you to Children's Wealth Management and APCO for being our VIP sponsors. Let me know if you all would like details on how to become a VIP sponsor and what all that entails. I'm going to follow up with you all in an email after today, and all the goodies will be there, and y'all just reach out to me directly. This is awesome. This is an interactive link for all of the Lunch.Learn.Leads that we have coming up. Make sure you get registered for those. You can also go to our website. There's your QR code if you'd like to register that way as well. We're super excited. This is what I'm really excited about. Last year was how many teams, Michelle?
37 teams.
37 teams for a first-time cornhole tournament. Even people that don't play cornhole came out to network, socialize, spread their news, their brand, all that good stuff, and just to support. It was fun. We had an absolute blast. So here's the register. Here's the QR code. We are looking, of course, for sponsors. I want to thank Republic Services, Rose City Cornhole, Children's Wealth, and APCO for sponsoring this event. It's going to be a blast, and looking forward to having you on. And it's going to be a little cooler than it was last year since we're having it later in September.
And if you want to stay later, the Toadies are playing at True Vine right after.
The Toadies, the group?
Yep.
Oh, my cool.
Yep.
Thank you, Shalon. Like I said, we're super excited to have a few of our amazing ambassadors. We're constantly looking for and trying to recruit ambassadors, like I said, to help advocate for the BBB. If any of you are interested in any of it, there's a QR code there. Kind of just gives you the details. We're going to get an updated picture eventually with all the new ambassadors and as well as... Sam, how long have you been an ambassador, friend?
Since 2011.
Wow. And Ed, what about you?
Oh, before the book of Psalms was written.
So it's just a great way for one, like I said, just to advocate for the BBB and grow our partnership together with your business as well. So here's some information on that. And now I'm going to let Johnny Gonzalez, our newest BBB ambassador, come up and introduce Eric.
Awesome. Yay.
Right. Get up, you can get over there right in front of there. You go.
Earlier introduced myself. I'm Johnny Gonzalez. I'm filling in for Justin. He unfortunately couldn't make it today. So I'll be reading off Eric Kolder's bio here. So Eric is an attorney whose practice focuses on employment, law compliance, and litigation. Prior to becoming an attorney, Eric worked as an accountant and passed the CPA exam, which helps him provide clients with legal advice from a real-world business perspective. Eric was a partner with Brady & Flock Law Firm in Tyler from 2017 to 2023. He is currently on a sabbatical to enjoy time with his wife and 4 young sons, but he plans to return to full-time practice in late 2024 or early 2025.
Woo! Welcome back, Eric.
And up here's fine. I guess the clicker here's...
The clicker's right there. Yes, sir. There you go.
Right. Well, like John said, I'm on a sabbatical, which is kind of weird for 30 years old. But the reason is because in 2023, I had a number of real-life scenarios happen, a couple of deaths in the family, multiple cancer diagnosis, and by the end of the year, that mostly cleared up. And so I talked about doing this with my wife for a few years, and I was like, well, that's not cute, I'm doing it. And so my things have been like going to the zoo and teaching my kids third grade math and stuff like that. So every day is priceless. So, but I will be back sooner than later. Like I said, probably by the end of the year, I'll be back full time. And so, in the meantime, though, I will say this: I had this come up. Is if any of you guys have a EEOC charge, or if you have a lawsuit filed against you, employment law related, do reach out to me by email. That's just my name at gmail.com. Because those things could start now, but they won't really heat up from the end of the year into next year, maybe the year after. And so by all means, like day-to-day advice, consulting type of compliance stuff, I'm not doing that when I'm out of the office full time and at home. But if something like that comes up, do reach out to me because there's not really anyone east of Dallas who does this type of work on the defense side besides me for some reason. And we'll get into why that might be the case because it's kind of a pain in the butt to keep track of all this stuff. But I do, on a trial lawyer, I do a lot of trials, did one in April, believe it or not, legal case, and I do advice on the compliance side. I think that helps me give better advice to people to try to minimize the risk of litigation. That's the ultimate downside of employment decisions, right, from a legal perspective. So anyway, if you have something like that in the meantime, do reach out to me because, again, there's not many people to help. And if you go to Dallas, we're going to pay twice as much.
Yeah.
And I'm biased, but I don't think the service is any better. So today, I'm going to do something a little different. How many of you guys, most of you guys have been to a presentation I've done before where I go through the case law update for the year. So those are the cases that have been published in the past year. And those are great because they give you a real-world example of how these laws are applied in the real world in court. So it's perfect. Every year I go through these cases and then we go to, okay, Americans with Disabilities Act, here's a lawsuit about that. What did the employer do right or wrong and how did it turn out? They're perfect. You go through what is the law and how is it applied here and what can you take from that. Because it changes, right? And we're going to talk about some changes that happened, but I'm not doing that today. I'm going to do that at the beginning of next year or something like that because I did the same thing here in November. The case law update. So there's only so much that's happened in 6 months on cases. But I'm going to try to not cover too much, which I have a bad habit of doing. I talk really fast, so I'm covering a lot. But I'm going to try to cover only 4 or 5 major topics that I think will be very helpful for employers going forward and kind of drill down on a little bit deeper, kind of big picture stuff. This will be a little bit different, but I hope it's informative. If anybody has a question or comment, by all means, raise your hand, keep things going. So first, let's kind of go overview. So first thing I'm going to talk about is the FTC, the Federal Trade Commission's supposed ban on non-compete agreements. I'm sure a lot of you heard about that in the news back in April. I talked about it, I think, in November, but about what happened. We're going to next talk about the overtime increase. So the overtime increase salary, that's what I'm talking about there. That also came out same day. Department of Labor, different alphabet soup of federal agencies. But we're going to talk about that. We're going to talk about DEI. It's not something I've talked about in the presentation before, and I can explain why, but it's in the news more and more. It seems to not go away, and it changes, and it shifts. And so I figured it's a good time to talk about it. And then this last one, it's not last one, I have a little hangover after that if I have time, but I want to drill down on the Gen Z demographics because I've done some research on this and read quite a bit about it over the past few months, and it is eye-opening. It definitely changes, I think, how employers should look at what's coming in the future. Because it is different. It's even unavoidably different because of the demographics in particular. And we're going to look at what they are and how you can respond to them as employers. So it was surprising to me, and I thought it was interesting. So we'll definitely get into that and what we can expect and how we can maybe prepare going forward. So first off, the FTC issued a final rule on April 23rd, supposedly banning all non-compete agreements nationwide. How many of you guys have signed a non-compete agreement? Okay.
Yeah.
How many of you ask your employees to sign non-competes? Okay. Well, there's a lot of kind of urban legends about them. That's probably not the right word. But I've heard many people tell me that they're not enforceable. So well, that's one. They've not enforced them many times. They are enforceable. And I've drafted lots of non-competes. I've litigated them on both sides, both to enforce them or to prevent or enforce them. And they are enforceable, but you better do it right. You better do it right on the front end. In Texas, that is. And it varies state by state. Well, if the FTC's final rule stands, there's no more non-competes in Texas, Louisiana, Arkansas, New York, California, nowhere. So that would be a major, major change in the law. So, just on the show of hands, I found something interesting I'll talk about in a second that I was kind of surprised to see. How many of you guys would support a nationwide ban on non-competes? Nobody. How many of you guys would support a change in the state law, so just Texas legislature, to ban non-competes? No, okay. The reason why I say that is because they passed the final rule. The effective date is September the 4th. So don't do anything now, one way or the other. And if it goes through, though, if it actually stands, it would ban all future non-competes. So from this date, September 4th forward, 0, no matter who you are. And it's even worse, and this is super rare in the law, it would invalidate all prior non-competes.
Oh, wow.
Oh, wow.
And as the employer, you have to send a letter to everybody saying, by the way, your agreement's not enforceable. The only exception are executives. There's some kind of executives that old non-competes they would allow to terminate. But that's it. So this is a huge deal. And that's why I say it invalidates the majority of existing non-competes. It's really the vast majority of existing non-competes. And again, this law varies state by state. This is not a uniform thing across the country. Some have easier laws to comply with, some harder. Texas is probably somewhere in the middle. I'll get into what the Texas law is on it, by the way, in a second. So, the reason I say that is because, let's go to the next slide here. Multiple legal challenges have been filed. Shocker. I mentioned that, I think, in November. Even if they have to file a rule saying no more non-competes, don't sweat it too much because it's going to be lawsuits. I'm sure that there was. Now, what's interesting is, the first case that I saw filed was here in Tyler. Federal court. So, venue-wise, so get a little nerdy legally, but like venue-wise, for some of those, you can file this in any federal court in the country. Because it's a nationwide ban, so if anybody wanted to challenge it, every jurisdiction, you could file this in, right? Because it's a nationwide thing. So what they chose, and who chose? Well, the U.S. Chamber of Commerce chose to file their case in Tyler, Texas. Yes, and it's because our district judges that were appointed by President Trump are very conservative. Now, I've had multiple cases in front of them. I think they're great. And I'm on the employer side, so keep that in mind normally in litigation. But even when they rule against me, which they do, they're right. You know? So they're super smart guys. They follow the law. But I thought it was a kind of a vote of confidence, almost. The U.S. Chamber of Commerce could have filed this case anywhere in the country, and they chose Tyler. And Judge Barker's only a few years older than me, and so is Judge Kolder. So they'll be here for a while unless they get appointed to an appellate court, which could happen. Who knows? But it would have been interesting because Judge Barker had dealt with an overtime lawsuit issue that was very contentious at the time in one of my cases. And he went kind of not with the typical rigmarole. And he thought, well, maybe the law should be different, or maybe the law is different here. And another case kind of answered the question. It's an open question, so he's not afraid at this point to kind of look at the law objectively and say, what does the statute say? What do the regulations say? What does the precedent say? And so it would have been really interesting to see how he dealt with this. But if you remember, did anybody remember 2016, the increase in the minimum salary that was passed, but then there was a judge in Texas who invalidated. Remember who that was? It was the Northern District of Texas. And it was in the Sherman Division. So, I can't remember his name. My mind's going blank. I kind of gave it my name as well. But, shoot, this comes to me later. I'm just going to blurt it out. But the point is, again, they could have filed it here, they filed it there. So they filed it here. But what happened was, I read his order the other day, someone filed a case a few days before that, actually, not the U.S. Chamber of Commerce, but I think it's an accounting firm, a couple days before, if I remember right, and he was in the Northern District of Texas. But it's another Trump appointee, Judge Ada Brown. So it's interesting to see what she's going to do with this. Now, everything I've read says expect a ruling in midsummer. So what is Judge Brown going to look at, or Judge Barker, what's he going to look at? Can the FTC even do this is the question. Because how many of you guys know what branch of government is the FTC a part of? The executive branch, not Congress. Right? So you have the Department of Labor, FTC, all the alphabet soup, they're part of the executive branch. That means that the people on the commission are appointed by the president. Same with NLRB. Well, this is a law, right? I mean, basically, if you're validating, it's a pretty drastic law. This seems like something Congress should do itself if it wants to do that. But, bureaucracies like the FTC have a mandate from Congress to do things within a certain boundary. Like the Department of Labor, they may issue rules in the Code of Federal Regulations interpreting or applying what Congress says about minimum wage, for example. And so it's like rulemaking, it's not lawmaking. I know there may be a distinction without a difference to some, but big policy decisions should be done by Congress, not by unelected people in the FTC. So that's what she's mainly going to look at. And I can tell you, I would be shocked if she came out with anything else besides this is a major overreach of the FTC's authority to do something like this. Now, will Congress do something similar? I don't think they will. I've never heard anything about it. But I saw something interesting when I looked up the Northern District case. There's something called an amicus brief, which means that if you're not a party to a lawsuit, you can file a brief with the court, if they let you, to say, I'm not a party, but I want to make my opinion or my beliefs known or argue for one side or the other. Now, this is very rare. When it's Supreme Court cases, it's very common. This is not a Supreme Court case. This is a district court case. It may have been a Supreme Court. And it was, if I saw this right, it was Matt Gates. Anyone know who Matt Gates is?
Yes.
He's a very conservative congressman. So he filed, again, I think I have this right, I didn't open it and read it all, but I did see it filed, and it was on behalf of the FTC. Which is interesting to me, right? Because you think the Biden administration, FTC, right, this is the executive branch currently, they ban non-competes. I think President Biden does support that, if I understand right. And then Gates is filing a brief to support the FTC banning non-competes. Now, some people are libertarians say, some libertarians may say no non-competes, there's a restraint on trade. So, okay, I don't know what his aim was on that, but I thought, well, that's interesting. I didn't expect him to be filing a brief supporting the FTC in this, or even to even file anything. So maybe there will be a political movement in the aftermath of this, where there may be a nationwide law. It's debatable whether Congress has the ability to do it either. But they're way more likely to than the FTC. So all that to say, if you have a non-compete, I would wait until September or August to even think about doing anything about it. I wouldn't worry about this because I'm fairly certain that Judge Brown will strike this down and say, beyond the FTC's reach. You may see everything in the news, things in the news depending on which site you read, but the reality is probably in the summer, it's not going to go anywhere. Now, what if it doesn't? Well, there's an election in November, and depending on how the executive branch changes, that could change. So, rewind 2016, increase in minimum salary, there was a judge's decision. I can picture his face. I can't. Anyway, he struck it down, but then Trump won the election, and so the Department of Labor wasn't trying to increase it anymore, right? So the election can affect this too. So even if Judge Brown would say this isn't FTC's purview, it may not last the election. Who knows? But so it has two kind of hurdles to clear. One, Judge Brown. Two, the election. Now, a little bit, Judge Brown will not see this, so I'll say it. I had a case in front of Judge Brown. It took 3.5 years to get ruling in one motion.
Wow.
So, yes. And the reporter from Fort Worth talked to me about the case, and she asked me about it, and it was still pending. I said, well, I haven't, she said, was this normal? I said, well, I haven't seen anything this morning. She puts that in the paper. Don't do that. Now, she hates me. I didn't say that. But if she gets a ruling by midsummer, I mean, I guess it depends what case it is, and how important this is, which is totally fine. I saw it was funny. I said, Judge Brown, in her defense, when she was appointed, she inherited a huge backlog of cases, so it's not. I'm going to think 4 years, or whatever. But anyway, now let's talk a little bit about non-competes in Texas. So, again, the Air Force Board, you may see someone maybe looks at part of the statute, not all of it. There is a statute in Business Congress that says non-competes are illegal restraining of trade. Yeah, that's true. Except for the next code section that says how you can have it enforceable. So, the big thing that people actually make mistakes on these is what if you have a non-compete, get an employer's example. I'm biased to get an employment lawyer example. Because I'm telling you, most lawyers do not do this type of law, and this is very particular. And I can tell you, full disclosure, you can draft it perfectly, and it doesn't mean it'll be enforced. Because the case law is so mixed on these that if the judge that you're in front of wants to enforce it, he will or she will, and if he doesn't, she won't. And you say, well, and now, if it's not enforceable at all, it's just poorly written, then you don't have a chance. You're not going to enforce it. Even if it's perfectly drafted, they may not. Why would that be? Are judges unfair? Judges are fair, but judges are human beings. Keep in mind, when these things play out, you have a worker, an employee, who's being told by the court, you can't work in this county, or whatever. You can't take this new job. So judges should be naturally pretty sympathetic to the employee. And that sort of makes sense, right? I mean, because you tell this person they probably have to move or whatever. But the big thing that even most lawyers make a mistake of that I've seen, and I can tell you, you get a scarecrow letter where it's unenforceable, and you get a scarecrow letter from the lawyer saying, you can't hire Joe Smith because there's a non-compete with an ABC company, and I can call a lawyer and say, this is crap, it's not enforceable. It's like, yeah, I figured that. Just send a letter, try to scare them, I'm not going to file a lawsuit. So that happens, just so you know, they're not so scared to get a letter about it. But the big mistake is it must be a part of another agreement. It's that simple. Think of it this way. If I pay anybody insurance, you can't be a lawyer in Smith County. I'm going to pay you $1,000 a week to be a lawyer in Smith County. That's not enforceable. That is the agreement. I'm just paying you not to compete. But what if you have an employment agreement? Or a non-disclosure agreement? Or you're looking to buy my business costs. I'm going to disclose some information to you. There has to be part of another agreement. In other words, if you take the non-compete out of the agreement, you still have an agreement. In my first example, you don't. The whole agreement is I'm paying you not to work. You can't do that. Now, what you'll see is employment agreements, and I see this all the time. And people who don't do this type of law don't know it. What if you have it's written and it's signed? Let's say it's signed in blood before the public, okay? And it says that it's employment agreement. When it says at will employment, what does that mean? That means you can quit right in front of you for no reason, no recourse. So yeah, it's on paper and it's signed and maybe notarized. That's not sufficient. Right? It's just you're just paying the guy not to work. That's what you're doing. I see that all the time. So the lesson is, if you want an enforceable non-compete, you have to make a commitment to the employee. And most of the time, that's a term. So in other words, let's say it's a one-year contract's fine, 2 years, whatever, and you can have for cause termination. You can do that for sure, right? You may have a lawsuit about what's for cause, but so be it. That makes sense. You're not at will. You can't just fire me for no reason. Imagine if we had an agreement and I pay you to have a non-compete, I just fire you for no reason. Well, now you can work in Smith County for 2 years? You see, that's why you don't want that. Michelle?
Sorry, just real quick, can you clarify what does it mean by Texas is a right to work state? Because that's what I hear on these non-competes and stuff. People are like, it'll never hold up.
It does.
What is the definition of that? What does that, I mean?
So I think the United States is an at-will state. It's an at-will state. So let's put union stuff aside for a second. Don't want anything union related. But when it comes to when people say that term, they don't mean the union version of right to work. They mean at will. Now, at-will employment means you can quit at any point, or they can fire at any point for no reason or a good reason. And for all these reasons, you can't. Yeah. Like your race, your religion, you say, you know what I mean? So at-will is the starting point.
Okay, gotcha.
But then you have, on top of that, if you have an employment contract. And I have an employment contract with you that says not, I can only find you for cause, and then it says for performance, it says general. And you think, well, I'm not performing well. Okay, well, you argue. I can sue you and say, not really, I did perform well. And sometimes it's a tough call. Is it really poor performance or not? But you're not willing when you have a contract. And not only that, even if you have no contract, you still have the anti-discrimination laws, which we'll talk about in a second. So I think people mean at will. That is what they generally mean by that. And so if you have a non-compete, at least keep part of the agreement. Just leave that as it may. It's normally an employment agreement. It can be many other things. And it can be a non-disclosure agreement. This is kind of the bare minimum you can have. So look, you're going to work for me, and I'm going to show you all my trade secrets. And in response, you're going to agree not to be with me. And generally, the restrictions are you have to have time, scope, and geography. Time is time. Scope means what type of work is restricted. So if I work me as an accountant, I can't say you can't work as a plumber in Texas, right? That makes no sense. And geography, what's the geographical scope of the agreement? Now, time, I can tell you, is 2 years and less generally enforceable. If you go more than 2 years, you better have a very good reason, like the sale of the business. So 2 years generally is the limit. And that kind of keeps creeping down a little bit, because again, you want people to be able to move and work. Scope generally means the type of work that employee did for you. So I'm CPA and accountant, but I'm not working as CPA and accountant for any fly. So if I had a non-compete with them and said, you can't work for $1.10, can't do that. I'm not working as an accountant for anything. I'm a lawyer. See what I mean? So it has to be what kind of work they did for you. Geography, generally, it is the counties in which they worked for you. This comes up all the time. I can tell you how it comes up. Your business does business in 6 counties. This guy works in 1 county. Your agreement says none of the counties that we do business in. It has to be just generally the counties that they work in. Now, if they're like EVP or owner, you can do business in 1. And then you're almost never going to be able to go beyond the scope of where your business service people. So those are the kind of general rules. Now, I won't get into details of this because this is the very stuff that I like. Is that even if you don't have number 1, part of another agreement, you have nothing. You will not be enforced. If you mess up on the second one, the time, scope, and geography, as long as you have them in there, even if they're too broad, so let's say you say 10 years, all legal work, all of Texas. The court will still enforce it, but they're going to take this red pin out. And this is why this stuff is so weird. Judges don't only amend your contracts and lawsuits, right? But in this one they will. They'll say, no, not 10 years, 2 years. Not all lawyers employment law. Not all of Texas, Smith County. That's what they do, East Texas. And the trick is, if it has to do that, whatever violations I've done before that point, the employer can't get any money. So I could have stolen 100 clients, but because they got a red pin, the employer can't get any damages for it. But going forward, I can't actually work in Smith County, right? That makes sense. So it's a very complicated rigmarole. This is what we're going to be dealing with, I guarantee you, January of next year too, right? It's not going anywhere. We'll get a brief overview of that. But yeah, I didn't know why Gates filed that. And go ahead.
I know for a non-compete to be valid, there's a consideration given by the employer.
Yes, sir.
Does that have to be commensurate with the amount that the employee is giving up, or how do you judge the appropriate amount of consideration is given to make sure that that's valid?
Very good question. And so, when it comes to being part of another agreement, you have to be trying to, so it has to be another agreement, so it has to be consideration, right, for another agreement for it to be a part of. And then, you have to be trying to protect something as a business that's valuable to you and that the non-compete is going to protect. So I have to kind of point to something, trade secrets or customer contact or something, some protective interest is what it's called, of my business that I'm trying to get you or whoever not to infringe on by promising not to compete. So there has to be consideration, but there also has to be some value to the business I'm trying to protect. And that right there is one of the ways that judges can kind of say yes or no and really get to the end result that they want to. But yeah, you definitely do have that consideration, and generally you have to have, it has to be something, NBA is a good example. Because if you're giving me trade secrets, I'm working for you, that's what you want to protect. And that's the consideration I'm giving, because that's valuable to me, it's valuable to you. I will compete against you tomorrow. And there you go. So not only you give me consideration, the information, but it's also related to why you want me not to compete. That's why just, I've seen this too. Give you $10,000 bonus for signing a non-compete. Maybe, but again, is the $10,000 related to why you want them not to compete? You see, that's the kind of logical connection. So yes, and more than that, it has to be connected to what you're trying to protect. Very good question. So this is not going anywhere. Follow the news though. I mean, I could be wrong. I mean, I would be very surprised. I'm kind of surprised that they even went forward with the rule in April, to be honest with you. I thought they would even said pretty much about it for quite a while, but they did, and so we'll see. All right, this one is a little bit different. How many of you guys have salaried workers for your companies? Most people do, right? So there's and I'll get into the next slide where I see mistakes on this more often than not. So the current minimum is $684 a week. I think that's for $35,000 a year approximately. The new rule bumps it up to $884 a week, $43,000 a year is the annual rate, and this is effective July 1st. But there's a second phase, January 1st, and that would be $1128 a week or $58,000 a week. That's a substantial jump. So it's going to be interesting to see why they do this, what ends up happening. And also, it's going to adjust every 3 years going forward. I don't know about you, put aside what you think about the amount. I think the last one makes sense, though. Right? I mean, like an adjustment based on inflation, cost of living, that type of thing. Sometimes that's not already a feature, it isn't. But I think most people would kind of come to a consensus on if we're going to have a minimum salary, maybe the same as minimum wage too, right? Kind of the same thing. That one is, I think, you might get more broad support on. So for July 1st, I would certainly, if you have salaried workers, either convert the salaried workers who are below that amount, below 80 for a week, to hourly, and you can revisit this in the beginning of the year to see what happens, or bump them up to the minimum. Because I don't think anything's going to happen before July 1st. There's cases that have been filed. We'll see. This is a lot closer in time, and I do wonder, I wish I could be in the room in the discussions, because if the two-phase, what's the logic on the two-phase thing? I mean, I guess 6 months is not really much time. Why do they do one step in July 1st, one step, why not do 1 year after the other? I don't know. I mean, they don't want to get struck down by a court again, right? Department of Labor. So there's some reason why they did this. I'm not really sure the reasoning behind it. But I can tell you, there are challenges. We'll see what happens with them. I wouldn't worry about the 1128 yet. I do think you'll probably get a preliminary ruling in the case before the end of the year. But you kind of be prepared. Now, one big thing about this is it's a three-game challenge, result uncertain. Again, the election, just like last time in 2016, if President Trump wins, I don't think this is going anywhere. I don't think that he's going to. So maybe I kind of hope the adjustment happens over time. I think that most people would. But outside of that, if President Trump wins re-election or election again, however you want to call this, I don't know this. There's no, I don't think, definitely not my life. I don't think in 100 years there's been a presidential election with two people who were both presidents. I think the last one was like 1900 something. I thought for sure that had happened in my lifetime, but it obviously did not. Yeah. Yeah, like I guess Bush's dad did everything against the deal, and another American issue. So the election may change it. But one thing I want to say is review. If you have salaried workers, review your exemptions anyway. You should do this periodically, because it could be a huge pain in your backside. Here's why. How many of you guys have gone through a Department of Labor investigation before? None? That's awesome. That's very rare. So somebody can sue you for unpaid overtime, right? They can file a lawsuit against you over overtime. And the issue that Judge Barker I mentioned was how he deals with those cases That's been kind of tailored back. You used to be able to file a lawsuit and say, oh, by the way, there's lots of people like me in this company. Let me send letters to everybody that work for you and see if you want to join my lawsuit. So it's not class action, but it's called collective action. It's very close. That's been tailored back a little bit. Because those are scary cases. You get one guy filing a lawsuit, he gets to send letters on court letterhead to all those employees he works with. Do you want to just sign this paper and join my lawsuit? So now I've had cases where one employee, one plaintiff turns to 100. Well, guess what the settlement value just did? And so Judge Walker was looking at that issue a couple years ago. The Fifth Circuit kind of changed it. It's a little bit harder to do now. Less of them are filed. They're not as scary. I used to talk about that a lot at these conferences, at these talks, because it's one small mistake on who's salary, who's not, or how you pay overtime, and it turns into a six-figure settlement overnight, very easily for the plaintiff.
In order to maintain your overhead, it's a practice even when I was in banking business back in the 70s and 80s, we would change full-time to part-time, and in order to maintain your overhead. Is there any type of prohibition where they're saying, okay, you were salaried, but now you're hourly, and now you're working 20 hours instead of 40 hours, and so is that just a function of the business, or they're not trying to oversee that area at all?
No, good point. So, and that's what I was going to get to here at the next, I'll get to the next slide, because you've got to get exactly what I'm going to in a second, is anybody can be hourly. It's always okay to be hourly. Even if you meet all the exemptions, you're paying 10 times the minimum salary, you can pay anybody hourly. It's never a violation to pay someone hourly. So sometimes people think of it as, well, if you qualify for the exemption, you have to give it to them, you have to pay them. No, you pay anybody hourly, and you have their hours, like you're saying. So we don't pay overtime, they don't work overtime. You can have a handbook policy. That's another thing to do a lot of handbook reviews and policies. A lot of them have at the beginning of next year. One of them is no overtime unless prior to approval. Okay, that's pretty strict. You schedule 35 hours a week to make sure that they have some wiggle room, kind of like you're saying. Now here's the thing, I'll throw this out there. What if you have no overtime without prior approval to the email, and somebody works 45? You have to pay them the extra 5? Yeah, you do. You can fire them. But, or write them up. You have to pay. I've seen that before. So, again, you can always change much hourly. And again, if you're worried about the July 1st thing, you can change hourly for the time being and then see what happens in January. It's always okay to be hourly. But here's the big thing that most, when I see mistakes on the overtime, the overtime exemption, the salary, it's very rarely the minimum salary. Most people can Google that, see, okay, I pay a salary and it's this amount, got it. And they think they're done with it. They're not done with it. You have to have only certain types of duties qualified for the exemption. So if you're an ordinary line worker, you can't be salaried, period. You can't. I mean, you can be paid salary, you can't be overtime too, is what I'm saying. The duties have to be executive, which kind of means management, administrative, which is like HR, legal, accounting, like non-main function kind of support. There's professional, there's like nurses, lawyers, doctors, outside sales. You have to be one of these categories. So you'll see a lot of times where workers, even managers that don't manage enough people, will be salaried and not paid overtime, and they're paid the minimum amount. That's fine, but they're not clear in the first hurdle, which is are your duties the type that qualify at all. So that's why I say review your exemption. Even if you know the amounts are all way more than 35. Okay, great. You may be okay with 43 per year. But review who is getting these exemptions and do their duties qualify. And I'll be honest with you guys, especially the administrative one, is not so clear. It's just people have been kind of bugging me, well, make this more clear for us to give us better predictive value. And a lot of regulations to try to help you, but it's kind of muddy. So if they're on the borderline, do they qualify or not? The safest thing is to make them out. Because again, you might be out. I mentioned this one at the bottom, and that's their primary duties. Their primary duties have to be of one of the types listed in the exemptions. So, not the most exciting thing, but it can be a big time pain. But the reason I mentioned the corporate labor investigation, let me get to this, is because they come in and they say, let's say I call, and I say, I'm going to pay mine. They're going to come in, they're not just going to look at mine, they're not going to say you call, number one. They're not going to just look at my pay, they're going to look at everybody's pay for the whole company for 2 years. So if you think one mistake, you have a bunch of employees, get ready because they're going to find it against everybody. They're not looking at just one employee. And you have to give your pay records, your time records, everything. Now, local investigators are very nice and have a relationship with them, but they have a job to do. I'm not trying to work with you, but they look at everybody for 2 years. I've had some clients that I've had a construction that shut down because it's flat out. And I disagree with the Department of Labor on that, he just shut it down. And I've had others, a couple of others that were close. It was that they had come back with that amount. They said, and restaurants are tough because of the tip credit, it's not clear, it's a mess. But yeah, so review your exemptions is my point, because the Department of Labor comes in, you have to comply with them, they will look at everybody for 2 years, and anyway, so be careful on that. What will happen though, what will happen in the challenges, I'm not really sure. I think this one maybe has a better chance of surviving the legal challenge than the 2016, because 2016 was more one step all the way to 50 something, maybe 58, I can't remember. It was a bigger jump, it was one step. And so that one got struck down. This one is stair step, they have a reason for it, it may withstand legal challenge. I don't know if Trump wins the election, it won't. But I would try to comply with it for the time being.
Because we're having such a change in our demographics and inflow of workers into the country now, how is the government really looking at the I-9 violations?
Yeah, so keep this in mind. If you knowingly employ as a contractor or an employee an illegal immigrant, you're criminally liable. Not just civil liable, you're criminally liable. So don't do it. If you know that the person's illegal, even if they've been working for 5 years, you find out it's not working to you, and sometimes what you have to find it. They come in, the ICE comes in, the Department of Labor will ask all the INIC for the wage and hour. And if you don't have finance for everybody, you're gonna have a problem. So I just feel required. That's the main method of them checking. Now, I will say this, I've had this happen. You don't have to be a document expert. If you're kind of thinking, this kind of looks fishy, but they give you, they have to give you originals, by the way, not copies of the source documents for I-9. But I've had clients say, I'm not sure if it's like an Oregon driver's license. It's like, I don't know. It's like, look, take it as their word. If it looks original, okay. You don't have to be like a forgery expert, is what I'm saying. You don't have to have the I-9, you have to have originals, and they will check it. And there's not just civil, there's criminal liability for that. So, if anybody employs minors, the unarranged worker violation stuff, penalties, civil money penalties from DOL, they're high, don't mess with that. Make sure to harmonize them. I's dotted, T's crossed, they don't play around. But yeah, I-9s, they will check, they have to have them, that's their main method of doing it. And I have people say, well, I'll just make it a contractor, you don't have to have an I-9 for a contractor. But if you know they're illegal, now you're still criminally liable, so don't do that either.
No.
Yeah. So DEI, you guys have heard about this, right? DEI programs. So these are mainly, DEI stands for diversity, equity, and inclusion. These are mostly big corporations that have these programs. Does anybody have a DEI program within their company? You do? Okay. All right. They don't come up too much, but big companies, they do, and they make a lot of news. So the popularity fluctuates. Sometimes you see people who say, these are great, or some people say they're dangerous, don't do them. It's kind of a cultural war issue. So putting the cultural issue aside, one thing to remember is they're not required. You don't have to do that. You hear some people talking about it as if you're required. You can do it, it's not required. Actually, believe it or not, no actual training for your employees on compliance is actually required by law. So I'm not saying you shouldn't do it, I do it. I ain't for clients. I'm just saying it's not required. Nobody can sue you or have a fine if you not have the program. But I've seen them, I've heard talked about, I've even talked to other law firms, not in town. I was like, I think that might go beyond the law. I think you might be opening yourself up for a lawsuit here. And the big issue with the DEI programs that I've seen, some of them, is that look, you can't treat people differently based on their race, or their gender, or their religion. It doesn't matter. Like, we're almost a plurality society, talking about demographics and plurality. There's no almost majority anymore, right? So, males can sue for sexual harassment and sexual discrimination, right? White people can sue for race discrimination. Christians sue for religious discrimination. So, anytime you're doing anything where you're treating people differently based on their race, or their religion, or their national origin, or their sexual orientation, or their disability, any of these things, even though you mean well, be very careful. Because there's somebody else that may not agree with you, right? So if you're favoring me because of whatever characteristic, well, then maybe just maybe someone else. And so this is one of the issues that DEI programs, I think, that people are concerned with, and companies are backing off, and big firms backing off, and saying, we want to decrease discrimination, decrease the possibility of litigation, and we may have created more than we want. Or maybe open ourselves up to something we didn't intend. So, yeah, the big takeaway is anytime you have any program that treats people differently based on any of those characteristics, it's just not a good idea. I just don't recommend it against it. It's too much of a risk. to do that. Another thing, and I've seen varying studies on this one, whether it actually leads to more disunity among employees or less. Because you like it to mean, at least from an interpersonal standpoint, people to mesh better. That's at least that. Forget about the legal side of it. And there's conflicting results on that. So are you getting more cohesiveness amongst your employees, or are you highlighting differences and making it a little more adversarial? There's mixed results on that. I don't know what the right answer is on that. But legally, if you have one, be very careful with it. Don't have a lawyer look at it. Because again, it could lead to something you don't intend, but it could certainly happen. Now, again, always be aware of treatment different based on these characteristics. Now, again, affirmative action was struck down for higher education in 2023 by the Supreme Court. Can't do that anymore. Can't use race as a factor in admissions anymore. That's a change. So there hasn't been a private sector DEI case I've seen come up yet, at least at appellate court or Supreme Court, but it could be coming. In other words, you could have the same situation you had with the affirmative action result, the DEI case in a private corporation, let's say. So, because it's the same court. Now, affirmative action withstood other challenges many years before that, but nothing changed, and now they say no. So I'm saying is that by the same logic, with the same justices, the DEI program comes up, and certainly the intention is not to harm anyone. Well, the affirmative action wasn't, the intention wasn't to harm anyone, but they struck it down. They can do the same thing here. And one thing to remember about everything we're talking about, when we're talking about employment law, culture moves much faster than the law does. For example, if I go and read a case from 10 years ago, in court, I had this happen at a trial. I won't say what I said, but like the judge raised your hand, and the jury said, look, that's in the cases. That's not my words. That's what the judges call this, not me. I have to use the legal terms. I can't use TikTok language, right? I have to use the legal language here. You may have a propensity to do certain things, and you think this is good or bad or whatever. Remember, the law moves a little bit slow. And so what may be very offensive or outrageous to the general public at some point may not be illegal yet. May not ever be illegal. It may not be discriminatory. So, and generally, culture now is probably less permissive than the law is. Well, that's a good or bad thing. But I think public opinion may be more harsh than the courts will be, actually, and the law is current. So that could be good for employers. Is that may not want it on social media, but it may not be a liability in court. Does that make sense? Let's look at the Muldrow case for a second. So I saw this case, a Supreme Court case, just a few months ago, and I saw this talked about a lot in the realm of DEI. I don't really understand why per se. I listened to the oral arguments, and it was very interesting. I read the opinion, and it's not a DEI case. It's not a DEI program. But what it was a lady who got transferred, and she said it was discriminatory. And what the end of the Supreme Court is, are transfers sufficiently severe or substantial to kind of base a discrimination case? Normally, it has to be an adverse employment action, which means hiring, firing, promotion, demotion. Transfer, I mean, is it enough? And they said, yes, it is enough. So a transfer can be discriminatory to the point where you can have a lawsuit. The old case law said you have to show not only that it was discriminatory based on some protected characteristic, but also it was causing significant harm. Well, what's interesting is in the oral argument, the plaintiff side wanted it to be, you have to show any harm. So all transfers, if it had anything to do with religion, race, disability, they all be discriminatory, and I don't have to show harm. So one of the justices asked the lawyer, well then, I guess both people, whoever was switched would have the case. So you can sue for something that actually ain't contested. What if it improves your terms and conditions of your employment? Yeah, that would be actionable too. They're like, that doesn't make sense.
Right.
So they kind of went in the middle and said, okay, you have to show that some harm, but not significant harm. Well, that opens a lot more transfers to the possibility of being the basis for a lawsuit. They didn't go as far as the plaintiff wanted, because I don't think that the plaintiff, I don't know what they were talking about, because if that would be passed, that means that every decision involving people of different protected classes, which almost every decision, we all differ on something, right? Generally. That both people would arguably have a basis, even if my lot is better after the promotion or the transfer or whatever. So they didn't go that far, thankfully. And it's a unanimous opinion, which is kind of rare. Unanimous opinion saying you don't have to show significant harm. So what that means is, again, all decisions, hiring, firing, hours, even transfers, I think this kind of brought in what kind of things you might see as the basis of a lawsuit. Now, most people probably would have already thought that was a bit, you could sue for that, right? Not so. You have to show significant harm to someone. You have to show that you are, again, race, sex, sexual orientation, all that list has to be a factor, motive factor, why the decision was made, and it has to make you worse off in some way. In some way. Doesn't have to be significant anymore. But again, I think people talk about this in DEI context because they feel like some of the DEI initiatives may fall into become, not necessarily just transfers, but I'm saying some of the initiatives may fall into kind of this rubric of looking at who works where, what hours, or whatever. I'm not really sure. It was not a DEI case. I'm hoping that I was expecting to hear talking about DEI program, right? Not at all. I think this is why we talked about it. It's an interesting case nonetheless, and it is important for us because, again, any decisions, hiring, firing, promotions, demotions, transfers, hours, these things, I think are only basis for a suit. Gen Z, I'll get into this, I have a little bit of time left. So I thought this was interesting. So Gen Z, and I have the years here, where's my years? So people born between 1997 and 2012. So pretty much anybody under 30 in the workforce currently would fall into the generation. So 30% identifies as LGBTQ+. So that was like 5%, I think, in my generation, if I remember the numbers right. Well, that is a big difference. So guess what you're going to see more claims of, just because of the numbers, right? You're going to see more, again, sexual orientation, gender identity, those things are protected categories now, based on Supreme Court a few years ago. It falls under the sex category of the Civil Rights Act. So that's going to be a much bigger issue going forward than it has been in the past. Again, it wasn't even unlawful until a few years ago at all for anybody. You could post it on Facebook, that's why you made your decision, and nothing would be done to you, legally. Now, not only is that not true, but the field of people that can have a claim for this, and this hasn't happened yet, but it will happen. There'll be somebody following heterosexual-based discrimination. That's going to happen. Something sexual orientation, right? That counts. So that's going to happen. And just like it's kind of last time, but again, there was a time when if you mentioned a male making a sexual discrimination case, they laugh. Not so uncommon. Same thing when it comes to Christian discrimination or white discrimination. Those things are very real. They're actionable. Because they were kind of a plurality society. And so what is interesting is that among Gen Z, only 22 are Protestant Christian, 14% Catholic Christian. So again, both of those are less than LGBTQ. And so that's a big change from prior generations. So, and then only 51% white. The next generation is, there is no majority anymore. I guess it's Generation Alpha, I think it's called, after Gen Z. So again, the idea that, and then 25% Hispanic, the Hispanic and white numbers are around what they have been, but white numbers are going down. And so what does that matter though? So the first thing I would say is, LGBTQ, it's not just a cultural issue. There's just more people that qualify. So, and again, you haven't seen it, but you will see at some point a heterosexual sexual orientation discrimination claim against someone. It's going to happen. But I wouldn't worry about that's not in the immediate future as much as the fact that whatever your politics or whatever your culture are, realize that this is applying to a lot of people and you may not know. And again, one thing good is if you don't know, it can't be a basis for your decision. So one of the early cases in Houston, before the Supreme Court case, was a transgender woman who said she did not get I think it was a hiring case, if I remember right, because she was transgender. But the defense had, we had no idea you were transgender, so it wasn't the basis. So okay, well, you win. But the judge went on the way to say in that case, oh, but this, if you did know, this it would have been a law. This is before the Supreme Court. It's unlawful now, there's no doubt about it. So I thought that was an interesting thing. Now, why do I bring up the other categories? For one, is because I think you're definitely going to see more LGBTQ discrimination cases just because of the numbers. That's the only thing to happen. And I guess the middle list and next is even a bigger issue. But this is my own guess. This generation, this is kind of just anecdotal and when people say it, they're a lot less averse to making a claim. So my generation is less averse than my parents' generation to making a claim of discrimination or harassment. My generation is much more open to do so. Well, Gen Z is even more open to do so. They're not embarrassed to do so. In fact, some of them are proud to do so. And kind of feel like it's the way they view discrimination and harassment claims, for better or for worse, is much, much different than mine. So there's more categories you can fall into to make a claim. And people are more likely to make a claim. And I've seen claims made that make no sense. It's like, I heard power harassment. What does that mean? Power harassment. When they said that on the stand, I was like, oh good, that's not illegal. Say it all day. I don't know what that even means. But here, again, the reason I bring up the Protestant Catholic and white is because I think there may be also religious claims, discrimination claims amongst Gen Z from categories you didn't see much of before. So what I mean by that is, maybe heterosexual, maybe Christians, maybe white folks. Because again, it's more accepted and the numbers are not, there's no majority, there's no group that we're looking at and saying, well, you hold all the cards and therefore you're not discriminating against. Anybody can be discriminated against now because we all fall into one of these categories or more of them. So there's more potential plans, there's more claims, and they're less averse to making the claims. So HR, regular, is going to be even more of a central aspect of your job. There's going to be a lot more bullets flying both ways. And to sort out what's culturally this and what's legally that is not going to be easy, but you have to at least follow the law. And sometimes following the culture means you violate the law. Like I said, it's not, I don't think an HR professional's job. It's good for me, right? It's good for lawyers. But this is the big one. So I thought the SBT number was much higher than I expected to see. But this one is actually pretty sad, and it's overwhelming. So remember, ADA, Americans with Disabilities Act, mental illness can be a disability. Anxiety, depression, PTSD, these are just any physical or mental condition that affects one or more main life activities. That's how it's defined. Well, mental illness counts. And the numbers here are much higher. You can see numbers, you see them up there, 42%, and you don't have to have a doctor's diagnosis, by the way, to be considered to have a disability. Now, you should have one if you really want to make your case stronger, but you may not have to have one, a diagnosis to make the argument you have a disability. Of mental illness.
Serious?
Yeah. And so again, you have to know about it, yes, but you don't have to say, I have a disability, you don't have to say that. But if the employer knows, you should have known, it was indicated that they did have a disability, and depression sort of counts as one, depending on its severity, anxiety, ADHD. But 42% of Jizzy has actual diagnosis. So 43% said they struggle with depression, doesn't need a diagnosis. 42%, it just happens to be the same number, it's not the same statistic. Actually have a diagnosis. And those four are in order of prevalence. So anxiety, depression, ADHD, PTSD. Now, look at the next one. 50% say that mental health is accident. In 2014, same age group, like different flesh and blood people, but same age group, rewind 10 years, 52% said they had accident mental health. 2004, 55%. So something's happened. This is a huge change. You think of disabilities, you think of more physical disabilities than what we think about. What if you saw, like paraplegic went from 1% to 30%? Whoa, what's going on here? This is what's happening. And so something's happening. I don't know why this is, guys, but it's real. And the reality is, legally, it does matter because each one of these people is a potential plaintiff and they have rights. As a disabled employee, they have rights under the law that we have to respect and we have to treat them as a disability. They don't have to use the magic word disability, those kind of things. And so anyway, these numbers are very surprising to me. So again, we have even the point of proselyte is even the numbers that went down, I think the likelihood of claims from those groups go up because they're not majority anymore. And then you have certain groups that have gone up, and there's more people that have made claims, so expect more claims from those people. This, I guarantee you, will lead to quite a bit of work for HR and consternation for employers. And here is one of the reasons why. So I mentioned this earlier. Here's kind of the takeaway here. I mentioned all these already, I think. Okay. The last one I want to jump ahead to is reasonable accommodations. So for race, for sex, sexual orientation, for age, you don't have to make any accommodations. Religion you do, but it's not as strong as disability. A big part of the ADA is, forget about hiring and firing and all that stuff. That's still prohibited to hire, fire, promote anything based on disability. That's true. But what comes up more often is you have to give reasonable accommodations if they need one. Well, this is a continual thing that you have to manage. So again, add in all the people that have disabilities, in Gen Z who didn't have this, increased number of people that have disabilities, and they ask for accommodations. They don't have to use the magic word reasonable accommodations, but they ask them time off, rehab, altered schedules, altered hours, altered duties, altered maybe locations. There's lots of things that can be considered a reasonable accommodation. But what does that mean? You make an accommodation for them to be able to perform the essential functions of their job with the accommodation. So you could think, I use this all the time because it's the best example I come across. I have a case where a guy had epilepsy, he was a crane operator. There's no accommodation. You just can't do the job because it's too risky. You have a seizure, right? So he'd been working for a few weeks. He told him, oh, I have epilepsy. He calls me, he's a good guy, good worker. We can't do that. So there are sometimes there's no accommodation possible. But you have to at least have the conversation. By the way, your duties as the employer is to have a conversation with them about it. You have to have a conversation with them, interactive process as it's called. You're a disabled employee that's asking for accommodation. And you have to, even if you know that there won't be one, you still have to have that conversation with them so you can have a conversation. And then you can discuss what might accommodate this person's disability. And again, with these, it's going to be kind of tough. It's going to be a person-by-person basis. And you may have a recommendation from their psychiatrist, for example, on what may accommodate and what may not. Now, here's another tricky part is, what if you think, I think this accommodates, and you think this other accommodation is better as an employee? Who gets to choose between one or more reasonable accommodations? The answer is the actual employer gets to choose. And there's good case law recently, including this year, affirming if I work for you and I say I need accommodation, I need 1 day off a week, and you say, actually, I'm just going to cut your hours back 5 hours to work every day, and I said, I quit, I'm suing. Well, the court says it's his choice. Both are reasonable, employer's choice, employee lose. But they have to both be reasonable, you have to have a discussion. And so I think that, I know, you're going to see a lot more reasonable accommodation requests from employees to employers based on mental health. Understand, mental illness is a disability, and you have to accommodate, and you have to have a discussion, and it doesn't have to go with whatever their doctor says per se, but you need to have a response in your own accommodation. And these are concrete things, it's not going to be easy to accommodate.
So when we hire somebody, they sign something at the bottom of their job description saying that I am able to do these, perform these, Does that offer any type of protection?
It does not.
Okay.
It doesn't. And they don't have to, so never ask if someone has a disability interview, which you don't know. Don't ever ask if someone does. But if someone discloses that, you have a discussion at that point. If they disclose to you that they did the interview. If somebody is asking for accommodation, you can ask follow-ups as to why. You don't want to ask someone's medical issue for no reason, right? But if you're saying I have trouble trying to work up to work on time, that kind of thing, or I need different hours or whatever, you can ask them about it. And by the way, if they say they have a disability, you can ask them for verification. So if I tell you that I have PTSD, you say, well, you have a diagnosis I can see, a medical exam, you can ask for that. But don't ask for it first, they have to kind of bring it up, is my point.
Okay.
But yeah, so I think that, I do think training is not required. I think training on managers.
What if that person doesn't tell you anything, but through the grapevine, another person comes to you and says, do you know that so-and-so has ADHD or whatever? How do you handle that? Can you go ask that employee then?
If they're having trouble fulfilling job duties, then you may want to have a conversation and say, you know, you're late on your work or whatever. Is there anything going on? That kind of thing. I wouldn't, if they haven't told you, I really would be hesitant to ask a direct question. But if there's a performance issue, think about, oh, there's ways you can ask without asking the direct question. You have ADHD, PTSD, whatever.
But if it's not a performance issue, you just probably need to leave that alone.
Right, because if they don't need accommodation, they're fine.
Okay.
You know, they're fine.
I noticed that job descriptions have become more specific in nature, and I think that's a way that a lot of employers have headed off this issue to let them know, okay, you need to be able to pick up 25 pounds. And so it gets extremely expensive, and not expensive, but specific, and so that if they don't qualify, they shouldn't be applying.
Well, another thing on that is that how would you draft a job description to deal with these issues, the mental health issues? I mean, it's going to be very difficult.
It's got not 100%, but at least you can head off some of the.
Oh, especially physical ones. Yeah, you're talking about physical ones. I mean, our job descriptions require me to know. They're generally a good idea. Because if I'm going to go and argue in court that says these things are requirements of the job, if I can point back to a job description that predates this employee, that would be nice. That helps me quite a bit. So those are the big takeaways from Gen Z. Again, mental health, LGBTQ, those two things are increasing dramatically. Mental health, I think, is a much bigger one. It's more people, and it requires decision making on compliance while they work for you. Not just in nuclear options when you get sued or claimed against you. Those are bad, right? But day-to-day decisions on how to deal with this. I think it's going to come into FMLA too. You have to have 50 or more employees for FMLA to apply to you. But again, serious health condition, you have to be, there's requirements, it's a higher hurdle for FMLA health condition than disability, but still it's going to come in there too. And just so you know, drug addiction is a disability, believe it or not. Not current drug use, drug addiction. Alcoholism, same thing. So you can't show up to work on drugs, can't show up to work drunk, but, you know, somebody, I need to go to drug rehab for drug addiction for 2 weeks. That's protected. That might be a reasonable accommodation. See what I mean? I've had this happen more than once. Those different things. And again, that's another one. I'm not talking about that. Opioid deaths are 110,000 this year. Insane. And that's 2 Vietnams a year, right? So those people, unfortunately, are dead. They're not making claims, but the people who struggled with it before that, it's apparently growing. So just throwing that out there to brighten the day. I'm just a good reaper today when it comes to some of this news. Some of Okay, so I had this come up, actually trial in April, had a labeling case, I went to trial, I decided to do it, and I was on sabbatical, it was fun. The one thing that you had to really appeal it is that the client was a contractor, so you know we've heard of whistleblower statutes, right? So normally that applies to government workers. Both of us would be protected from retaliation, makes sense. Private, by the way, no such thing. And then actually healthcare. You work in healthcare, you have protection. If you want treatment or whatever is going on, you have protection. But the way this statute is treated, it only applies to hospitals and facilities. Employees of hospitals and facilities. Well, what if I'm a contractor where my employees work in somebody else's facility? Does it apply? The way the statute, the answer should be no. It should. The judge, in this case, in Dallas, we thank you, Wilson County, by the way, not all judges are the same, but it was actually an article I read. It was from, her political party put on ads that anybody qualified as softball party, please make it, sir. Her own party. So she's one of the worst, unfortunately. Very nice as well, very polite. But anyway, I think she made a mistake here, regardless. I think it'll be appealed. We are appealing it. And she allowed the jury to answer the question and apply the whistleblower statutes to contractors within facilities. I think it's a wrong decision, but I do think that if the legislature gets rid of this through the appeal, they may change the statute, because I do think that's probably the policy. They probably want anybody involved in healthcare to be protected and have a whistleblower, and not just those who are hospitals or facilities. So that's not the way it's written now. That may be the way it's written in the future. I don't think it applies. One of the make was simply, if you have a whistleblower, just to be safe, treat him as if it does apply. That's all I was going to say.
Was that a travel nurse?
No, it was rehab services provided in a nursing home.
Okay.
So they have to apply
They
it
could,
too.
yeah.
They would apply it too. Unless you're for the hospital facility, that statute doesn't apply. That's the way it's written. It's probably not what was intended, but that's the way it's written. And so we'll see what happens. Any questions? I don't think we're over my time. Any questions? Anything I can help with?
Can you talk about internships? What are the rules?
Oh yeah, so unpaid internships.
Either, I mean,
So paid internships are fine. As long as you pay a minimum wage, you're good. No problem there. I'm not gonna get all the rules off the top of my head. The 5 factors. I did this for you guys like 3 or 4 years ago. Remember?
so those haven't changed?
No.
Okay,
Not
okay.
aware. No.
Okay.
They haven't changed. I don't want to speak out of turn. What's wrong on that? Generally, I'll say this really has to be part of we get credit for it, that type of thing. But there was a change to make them a little more strict and all that. And so, if you have unpaid internships, review the rules. I don't know off the top of my head on that.
Okay.
But if you pay interns, you're fine.